are bad. Now, I submit to you, go to the Roe versus Wade decision, take a look at this, and we are told that really there is no precedent for personhood. Now, this is narrowly construed in the context of the 14th Amendment, and we'll talk about that later. But the key thought, of course, is at the end of the day, the Supreme Court basically is saying that there is no precedent for fetal personhood. I just beg to differ. In this book here, and I'm not going to go into all of them, but in the 10 Universal Principles book, what you're going to see is there are literally dozens of precedents. You know, unborn human beings can actually inherit. That's a right. And if it's a right, then that being's rights are protected under the law. What does that mean? They are a person. A person, a legal person, has rights protected under the law. If the right to inheritance is not a right, I just simply am baffled. But of course it's a right. And those rights are protected under the law. There's a person. Oh, by the way, if you injure that unborn human being by negligence or some other reason, in utero, the parents can sue you for the injury, but later on, that unborn human being, now having been born, can sue you for the injury received in utero. Well, if that doesn't mean that they have the right to sue you for injuries, which means, of course, that their rights are protected under the law, which means that they're persons, as you can see, as you kind of pile up all the cases for fetal personhood, the personhood of the unborn, it is substantial. So the whole idea that the Supreme Court is not able to find a notion of fetal personhood is ridiculous. Now, of course, as I said, they did it by talking about fetal personhood within the context of the 14th Amendment vis-a-vis the states. But for all intents and purposes, this is a distinction that absolutely has no reality at all. It's just pure bogusness. Persons are persons. You can't just have a person with respect to the 14th Amendment versus a person with respect to the rest of the law or the Constitution or natural rights. I mean, just the whole idea that you can kind of narrow the view of person to only in the 14th Amendment is absurd. And by the way, you know, the majority in the Supreme Court admitted that the appellant's case would literally fall apart if Texas could have proven that the fetus was a person. Well, Texas could have proven that the fetus was a person. All that Texas couldn't was prove that it was a person according to the strict criteria of the 14th Amendment pertaining to states, which, as I said, is a completely bogus narrowing of the notion of person. Person, once more, is person under whose rights is a human being whose rights are protected under the law. Now, what does that mean? That means you have a blatant contradiction. On the one hand, you are saying that a fetal person can be aborted and therefore his or her right to life is not protected. On the other hand, you're saying that the same fetal, unborn human being is a person through the right of inheritance, the right to sue upon injury, and of course, even criminal offenses can attach to injuring that person in utero. Wow, there's a thought. Criminal offenses can attach to injuring a fetus in utero. If that's not a person, if that human being's rights are not protected under the law, I don't get it. I think this is an out-and-out contradiction, and I think that the court should be called upon it because, of course, it invalidates the opinion from the very beginning. And the court knows it. The court artificially made a narrow interpretation of the notion of personhood so they could get away with a blatant contradiction. Needs to